So we have the communal system as the ideal, and then we have the reality of these systems that much of the theoretical work and much of the discussion I think we'll have today, judging from some of the papers, will play on. I mean, how exactly do you develop these three particular notions? And then I want to then add the future when we're talking about the commons. I call it after the commons. It may be, you know, commons 2.0. There are all sorts of labels I could put to this. But I think we're sort of grappling with some very difficult issues now when we're focusing on those, on the details. And so part of my slide here, part of my discussion here is to step back a little bit and to take a look at some of the issues of the commons that have come up and how we've structured it. So there are at least three different notions of the commons if you're thinking about it from a little bit of a distance. We think often about the commons as the commons of liberty, right? So we often frame the commons in terms of what individual rights parties have to engage with the commons. And this has given rise to both, you know, what Garrett Hardin talked about as the tragedy of the commons. So Garrett Hardin's notion of the commons was very much caught up in a very, for lack of a better word, I guess, libertarian notion of the commons, that everybody has the freedom to act in a particular way, and then within that freedom, resources get depleted, resources get wasted, and therefore we need to have a movement away from the commons. And the movement from the commons could occur within Garrett Hardin's framework in terms of defining individual property rights. In other words, channeling the very liberty that destroys the commons, in Garrett Hardin's view, into sort of private property rights and so forth. Ironically, Garrett Hardin's view would also give rise to strong states. If you think about Garrett Hardin's use in terms of population growth, which is one of the big, there was a very Malthusian notion in Garrett Hardin's notion of the commons and the tragedy, which would not only give rise to individual property rights, but may also give rise to the state intruding. In other words, the state taking all the property rights and then putting limitations on reproductive freedom. And while there may at the same time be great freedom for economic development and economic growth. So Hardin is a very, I think, confused, I was going to say complicated, but I might as well just use the word confused notion of the commons that arises. But other notions of the commons also are based too much on some notion of freedom or liberty. And again, I'm not trying to chastise liberty or freedom by any means. I'm just saying it has to be tempered with other types of values, and we need to think about how to do that. So even, you know, some notions of the public domain, and so I give a little hat tip, as we say on the internet, to my colleagues Madhavi Sundar and Anupam Chander, who've written about the romance of the public domain. And their notion of the romance of the public domain, as I would interpret it, is that we talk about the public domain, but we really don't talk about how rights actually would work informally within the public domain. Would it be a situation where within the freedom, so it's not so much a tragedy as Garrett Hardin would describe, I would say, because that is a sort of a confused notion that he gives, but we think about the public domain as if there's equality when there probably isn't equality in the public domain. There may be a misdistribution of rights. Some people are more free to exercise their rights than others. And therefore, we need to think about how we understand and structure the public domain and not assume this kind of binary between proprietary rights and public domain. So we have other notions of the commons that can arise. There could be a commons that is based on equality. And I think during our breakfast this morning, we were talking a little bit with one of our hosts about the Israeli experience with the kibbutz, the kibbutzim. And so there's this notion about equality itself not being a sustainable sort of model or pure equality. But again, the question is one of tempering, right? What is the balance between freedom and equality that we want to have within the legal system that structures the commons, which may then give rise to some notion of the commons of justice, where we're thinking about systems or notions of justice that take account both of liberty and equality and try to have some way of balancing, to again use the wonderful language from Dr. Braverman's talk. I'm just stealing other people's talks. I didn't expect to do this. But I felt I was surprised in listening to it, how much there was, at least I read it, a resonance with some of the comments that I wanted to make after his. So, okay, so how do we think about the commons of justice? How are the different areas of justice that come into play here? And again, this is something I've written about in my own work on intellectual property systems more broadly. We can think about justice working through expertise. There's certain groups who either know better for other people how to do it, or it could be expertise that's not top down, but it could be bottom up. that you look to see how individuals have structured their own communities or their own knowledge systems and use that as some sort of a benchmark or a template in terms of developing what might be a societal notion or a practical notion of justice. There's a role for civic participation. So here the notion of justice may be a little bit more agnostic. We have no idea what a just world would look like, but we can develop processes. I mean, lawyers are very good at develop processes. Maybe they're less good at substance in many situations, but at least we can create processes within which justice can arise. There's a notion of market failure, again, to go back to the commodification notion. We often think about market failure only in terms of a loss of efficiency, but market failure can also arise from informational problems, loss of access, concentration within the marketplace through monopolization, and through waste, through simple waste. We often think about waste happening at the governmental level, but there's so much waste that's happening at the private level in terms of the resources that are invested in financial markets, corporate waste, possibly in terms of salaries, corporate waste that might occur in terms of projects that never go anywhere, that may end up only serving as tax write-off type purposes, and so forth. So you need to think about justice in that context. And then finally, in terms of management, I think about management here as synonymous with notions of autonomy. How do groups then decide, or individuals decide, how to manage their resources, how to manage their knowledge, and so how do we just develop justice that allows for that degree of autonomy. Okay, so I have about, I guess I had 2 minutes a few seconds ago, so I have less than 2 minutes now. And so what I want to do for the remainder of the slides, and I'll be glad to take any questions, is kind of go through them and then highlight the main points. So I've developed a lot of writings recently about distributive justice and intellectual property, and they focus on some issues of benefit sharing as well as social investment, and thinking about them in justice terms, not just simply maximizing the pie, but determining how the spoils, so to speak, are going to be divided. There are issues of intergenerational justice that I want to really highlight, because this, I think, has also kind of been implicit in my comments. I've talked about intellectual property systems and traditional knowledge, and in doing that, I've been very conscious in pointing out that they probably are different, that intellectual property systems operate within their own sets of rules of innovation, and traditional knowledge systems operate within their own sets of rules of how we maintain knowledge, use knowledge, and so forth, but they may be very different. But here there may be some overlap with intellectual property, as I put on at the very first bullet point, that as with intellectual property systems, there may be multiple types of public domains. There's not just simply one public within which the traditional knowledge systems operate. As with intellectual property systems, we're trying to think about institutions for preserving and transmitting knowledge. So it's not just simply about commodifying the knowledge, but even within intellectual property systems, we're thinking about preserving and transmitting it, but we're operating at very different types of systems when you're talking about traditional knowledge and intellectual property. And it's also important to understand issues of tacit and codified knowledge. Certainly within intellectual property, the idea of codified knowledge comes up at sort of the high water mark with patents and certain types of copyrights. But with tacit knowledge, we're often talking about trade secret systems, or even trademark type systems, where the knowledge is not so much formalized, but maybe implicit. So my example for a trademark system is that consumers might have certain types of marks that they think about when they, there's a whole culture of trademarks that might surround, for example, sports teams, racing. All of those represent some sort of tacit cultural knowledge rather than formalized knowledge. And so we need to think about both of those types of knowledge, whether we're thinking about intellectual property or we're thinking about traditional knowledge. And then I'll jump to the last point on this slide about identifying constituencies. That can be very important in terms of creating both intellectual property and traditional knowledge systems. So we often think about the constituencies, especially when we think about intellectual property systems, as either in terms of authors or inventors. But when we start thinking about forms of traditional knowledge, we need to think beyond authors, inventors. We need to think about users. We need to think about a class that I will define as preservers. Those could be universities, those could be museums. And again, the idea is not that knowledge is meant to be static, put behind the glass, hung on the wall, mounted somewhere. But even museums are recognizing that their collections serve a purpose of not just simply preserving, but also engaging with new generations that are relearning or rediscovering cultural artifacts from the past. So I think, you know, one of the points in my writing about traditional knowledge and intellectual property systems is that they are different, but they do intersect. And so what this talk is trying to do is give you sort of a normative framework for that intersection, as well as sort of recognizing some of the political and other implications for that intersection. So I'm going to go into turbo mode, as they say, but not so fast that the translators will have their heads explode or something. So let's talk about different types of models that can arise. And so the literature talks about several types of models for traditional knowledge systems and how they may fit within intellectual property systems. Thomas Cotier has written largely about how traditional IP models would work for traditional knowledge, so how we think about both from an offensive and a defensive system to deal with traditional knowledge. And certainly, as I was mentioning, I think with some folks at dinner last night, the US reforms to the patent system unwittingly, I think, have some implications for traditional knowledge. And one of the big issues, as many people know, is that within the US patent system, if there was knowledge, anything that was known or used by the general public or constituencies within the general public, they could be prior art, but only if they were known or used in the US. So if there was some sort of knowledge about the use of a traditional medicine outside the US, that would not constitute prior art. So that's why within India, for example, you think about NGOs, you have organizations like Srishti, and you have organizations like the Honeybee Network that started trying to write down or publish traditional knowledge, because prior art under the US system would include publications that would occur anywhere in the world. So one of the interesting developments within the US patent reform that took place in September of this year is that one aspect of prior art is known or used anywhere in the world. So the notion of prior art has expanded in some ways. Now I give this as an example, partly to inform you about this change in the law that has some interesting implications, but also it's sort of representing Cotier's point, right? Not to dismiss Cotier's point, but Cotier's point is, you know, traditional IP systems themselves are not static. They too can be expanded within its contours to deal with these issues, and this expansion of prior art is one issue. The problem of Cotier's system, though, is how do you deal with commodification? How do you deal with the multinational that takes traditional knowledge and then makes money off of it, but doesn't necessarily compensate any of the other constituencies? So Jerome Reichman's point about a compensatory licensing regime for traditional knowledge, again, in some ways within the contours of traditional IP, but he does view it as very different than traditional IP, that there would be an obligation to compensate the holders of traditional knowledge if, let's say, a multinational or other entity has found intellectual property and then has tried to commodify it. So you see some of Reichman's approach being implemented through things like benefit sharing and these types of agreements that are done more informally rather than through any sort of formal legal obligation. Reichman would want to make that more formal, you know, much like a compulsory licensing system that exists, for example, in broadcasting, that exists for music within intellectual property. Okay, so there's the unfair competition model, which I think has its pluses and minuses, but that would look to things like competition law, antitrust law, to try to deal with concentration, so that if the knowledge of intellectual property is somehow concentrated within a few companies, then there may be that type of intervention. That's an interesting point I put here. It hasn't been tried. I think, to be fair, it hasn't really been tried, but it might, you know, be consistent with some of the other normative notions of globalization that we've talked about. What has been tried, which I think, you know, creates sort of an interesting intersection between the economics and the politics and the broader normative frameworks, are the role of NGOs. And I mentioned several NGOs that have been active in India that have tried to deal with these issues of traditional knowledge by giving voice to various types of constituencies, whether dealing with genetic resources, as with the National Botanical Research Institute, or dealing with things like folklore or traditional culture and music with Guyane or with the Honeybee Network. And this is the last point that I want to make. So there are 3 points, if you remember. One about the commons, one about issues of justice, and then finally the legal meets the social. So I found this framework that goes to 2 scholars, Haverkorten and Renchis, that have written about different modes of knowledge. And I think it's useful to think about different modes of knowledge and the conflicts between knowledge. And so I would like to end with this slide, which I think is sort of the future, that we think about traditional knowledge as fixed, holistic, unchanging, while intellectual property and legal systems have to do with innovation and modernism, maybe even postmodernism, post-postmodernism, whatever those types of things. But I think in that interaction are sort of clashes between, or at least tensions between different modes of knowledge. So Haverkorten and Renchis have a very interesting set of taxonomy for different types of knowledge, where they talk about the clash. And sometimes we think about this purely in terms of the clash, the traditional versus the modern. But we also have issues of knowledge that might arise through underground systems. So there may be a majoritarian notion of knowledge and culture, but there may be sort of underground notions that might arise, for example, through individual networks, through, especially with the internet, and you think about things like the blogosphere operating, where this kind of underground system of knowledge can operate in parallel with more formal systems and so forth. So if I had more time, I would end with a more discussion about these different modes of knowledge. But I just want to put this on the table because we tend to think about traditional knowledge in binary terms. And I think with the development that we've seen in the last decade or so in the scholarly and the policy and the legal literature, we're now moving to a more sophisticated notion about how traditional knowledge can fit within intellectual property systems that really is breaking out of this binary sort of mold. So I'll end there. So sorry if I went on too long, but thank you.